1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်288ဦးဂျမာ Appellant vs Map B Respondent ဤစီရင်ထုံး Audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil Second Appeal Before ဦးစိန်သင်း Judge ဦးဂျမာ Appellant vs Map B Respondent Suit for specific performance of contract or a contract between the parties, whether the contract has been proved, whether the appellate court is justified in disagreeing with the finding of the trial court, intention of the party determining factor, whether or not time was the essence of the contract, whether the suit is time-bar. Hell, it is an admitted fact that the alleged contract was made orally between parties whose relationship was not such as to inspire trust towards each other. The transaction involved property, the value of which was quite substantial. It would therefore be ludicrous to suppose that the contract in question was effected orally and that no step whatsoever had been initiated for the last 4 years or more since the defendant first started betraying signs that she was not going to fulfill the terms of it. Therefore, the trial court was justified in holding the contract to have been not proved. This finding was arrived at by the lower court in spite of the testimony of 3 witnesses whom it had seen and had before it. The first appellate court, which did not see and hear these witnesses, was therefore not justified in holding that this evidence could override the facts and circumstances appearing on the record of the lower court in favor of the defendant. Chinaya vs. Ukha 14 Rangoon page 11 Utan Appellant vs. Dogun Respondent BLR 1957 8C page 73 Matintin vs. Doganshi 1948 BLR 582 refer to Hell Father. It was the intention of the parties which must be considered as a factor in determining whether or not time was the essence of the contract. Hell Father, it was the intention of the parties which must be considered as a factor in determining whether or not time was the essence of the contract. It is in evidence that the plaintiff first wanted to have the transaction completed on the next day. It was only at the request of the defendant that an agreement was reached by which the defendant promised to implement her part of the contract within 15 days from the date of the original contract. Thus, it seemed clear that amongst themselves, the parties have definitely chosen a time limit within which the terms of the contract were to be completed. There is nothing vague or indefinite about the time phase, since it was clearly laid down as 15 days. Therefore, the cause of action arose as early as the 28th November 1959, when the defendant failed to perform her part of the contract, as the suit was filed only on the 15th January 1964, it was clearly time-barred. Ram Karishma and another versus Les Minarian and another AIR Nagpur 1929 page 164 K. Saya Nara Jana Madi versus Saya Nara Jana Madi AIR 1925 Madras 211 refer to Lanyo for the appellant, J. Emmanuel for the respondent, Usain Judge, the plaintiff appellant JAMA sued the defendant respondent, B. Specific performance of contract in the Subdivisional Code of Meitila. His case, as set out in the plaint, being as follows. On the 13th November 1959, the defendant, B, entered into an oral contract by which she agreed to sell out a tenanted house and its site, hereinafter referred to as the suit property, to the plaintiff for a sum of $2,500. In pursuance of this agreement, B accepted an advance of $800 and, having handed over her title deed, surrendered possession of the suit property to the plaintiff. It was also stipulated that, on payment of the balance of $1,700, the defendant would execute a registered conveyance in favor of the plaintiff. Thereafter, the plaintiff, on several occasions, called upon the defendant to implement the contract, but to no avail. On the 14th March 1962, the defendant served a notice calling on the tenants of the suit property to pay up the areas of rent due to her. The plaintiff, by way of replying to the notice on behalf of the tenants, sent a letter to the defendant stating that he was the owner by virtue of the contract which he had entered into with the defendant. In spite of this objection, the plaintiff again sent another notice, dated the 11th November 1963, this time calling upon the tenants to quit the suit property. Hence, this suit by the plaintiff for specific performance of the contract for sale of the suit property, by accepting the sum of $1,700 being the balance of purchase money remaining unpaid by him. The defense cited by the defendant was one of total denial. According to her, no contract whatsoever was ever entered upon between her and the plaintiff in respect of the suit property. It was also asserted that the title deed in respect of the suit property was lost by her and that the matter had not only been advertised in a local newspaper but was also reported to the police. Thus, the main issue in the case was whether or not the defendant entered into a contract as alleged by the plaintiff. The plaintiff was able to produce the title deed, which was alleged to have been made over to him by the plaintiff at the time of the transaction. Evidence was also led to show that it was in the house of Mat Teng Shin, plaintiff witness 1, that the contract was made and that beside the parties to the contract, Matthew, Sayau, plaintiff witness 2, and Ko Tua In, plaintiff witness 3, were present when the transaction took place. It was also asserted that the plaintiff made an endorsement at the back of the title deed, evidencing the payment of debt 800 as advance money and that taxes for a certain period were paid by the plaintiff. The defendant, on the other hand, would have the court hold that the title deed was lost from her possession sometime in the year 1962 when she shifted her residence. Documentary evidence was produced to show that she advertised about the loss of it in Bahosi Daily, Uji Defendant Witness 3, a police station rider, was also examined to prove her report to the police regarding the loss of her title deed. Some tax receipts were also tendered as exhibit to show that she bore the tax for the suit property. The trial court, after discussing the evidence adduced by the parties, came to the conclusion that the alleged contract for sale of the suit property was not proof. It was, however, pointed out that some sort of transaction involving payment of debt 800 and resembling that of a mortgage by deposit of title deed did take place between the parties, but in view of the inordinate delay in filing the suit, the learned trial judge was of opinion that the transaction could not have been a contract for sale of the suit property. It was also held, though hardly necessary in view of the finding already arrived at, that the suit was time-barred. The suit was accordingly dismissed, each party being ordered to bear its own course. On appeal to the district court, Zhao said the learned district judge did not concur with the finding arrived at by the trial court that the contract for sale was not proof, observing that the fact that the defendant was able to produce tax receipts that she had advertised and reported about the loss of her title deed, and that the tenancy of 2 rooms in the suit house was given by herself personally to the tenants, could not override the evidence given by the person who had witnessed the transaction between the parties. The learned district judge held that there was a contract for sale between the parties. He, however, agreed with the trial court that the suit was time-barred and accordingly dismissed the appeal with course throughout. Hence, this second appeal before me. The main ground of appeal before me now is that the lower court erred in holding that the plaintiff's suit was time-barred, but as this appeal could be disposed of on another ground not relating to the question of limitation, I would therefore discussing this matter. The first point to be considered in this appeal is whether the first appellate court was justified in disturbing the finding arrived at by the trial court that the alleged contract for sale was not proof, in view of the fact that the oral evidence obtained on the record of the lower court was inconclusive either way, unless it can be shown that the decision of the trial court was plainly wrong it was not competent for the first appellate court to interfere with it. This is the principle which was clearly laid down in the case of Chinaya vs. Ukha 1N, which was followed by this court in Uttamad Appellant vs. Dogong Respondent 2, where the following had no appeal. Where there is a conflict of oral evidence and the issue in the case depends upon the credibility of the witnesses, a court of appeal ought to bear in mind that it does not see or rehear the witnesses and should not interfere with the decision arrived at by the trial judge, unless it comes to the conclusion that the trial court was plainly wrong. Thus, in the light of the principle propounded above, it would be necessary to determine whether it could be said that the finding of the trial court was one in which the error was palpably discernible as the evidence adduced by the parties was conflicting, the alleged contract between the parties being an oral one. A heavy burden rested upon the plaintiff to prove his case. No doubt, the payment of Jet 800 as advance money was alleged to have been induced in writing at the foot of the reverse of the exhibit title deed, but the entry was made in pencil without any signature appended to it. The year of the transaction was also wrongly mentioned as 1921. Therefore, the trial court seemed justified in considering it as a piece of work done in the slide. The only question that remains to be considered is the sufficiency or otherwise of the oral testimony of the witnesses regarding the existence of the oral contract between the parties. First of all, the plaintiff, JAMA, would have the court hold that no instrument was executed to evidence the transaction, as he trusted the defendant Dobby, who had been intimately known to him for many years previous to the making of the contract. This is, however, not warranted by the fact and circumstances obtaining on the record of the case, for it is in evidence that parties came to know each other only a few months before the alleged transaction and that the plaintiff did not even know the exact locality of the defendant's house. Therefore, the odds are against the plaintiff's story that he handed over Jet 800 to the defendant without requiring the latter to acknowledge receipt of it in writing. No doubt, Mathain plaintiff witness 1, Sayau, plaintiff witness 2, and Ko Tua In, plaintiff witness 3, try to corroborate the statements of the plaintiff regarding the agreement entered into between the parties. But here again, their evidence is not free from doubt. For instance, there is discrepancy between the evidence of Mathain and that of the other witnesses regarding the manner in which they all arrived at her house. Equally inconclusive is the evidence tendered by the defendant. The trial court accordingly observed that, as the evidence adduced by the parties are conflicting, it is rather difficult to say which side is true. In such a dilemma, the lower court would be competent to invoke the principle laid down in Matindin vs. Doganshi 3 to the effect that it should consider which story fits in with the admitted circumstances and resulting probabilities. In the present case before me, it is an admitted fact that the alleged contract was made orally between the parties, whose relationship was not such as to inspire complete trust towards each other. The transaction involved property, the value of which was quite substantial. It would therefore be ludicrous to suppose that the contract in question was effected orally and that no step whatsoever had been initiated for the last 4 years or more since the defendant first started betraying signs that she was not going to fulfill the terms of it. I'm therefore inclined to the view that the trial court was justified in holding the contract to have been not proof. This finding was arrived at by the lower court in spite of the testimony of 3 witnesses whom it had seen and had before it. The first appellate court, which did not see and hear these witnesses, was therefore not justified in holding that this evidence could override the facts and circumstances appearing on the record of the lower court in favor of the defendant. In this connection, the reason why the trial court should be considered in a much better position to correctly weigh this evidence than the first appellate court could be summed up in the following words of Viscount Sankey, which were quoted with approval in the case of Chinaya cited above. Witnesses without any conscious bias towards a conclusion may have, in their demeanor, in their manner, in their hesitation, in the nuance of their expressions, in even the terms of eyelid, left an impression upon the man who saw and heard them which can never be reproduced in the printed page. The learned counsel for the appellant makes most of the fact that his client have been paying tax for the suit property, but it is also common ground that the defendant had also paid tax for a certain period, as the plaintiff started paying tax only subsequent to the advertisement appearing in the Bahosi Daily. I do not think this fact should weigh heavily against the defendant. In any case, as the plaintiff has not been able to bring home his allegation regarding the execution of the contract, I would hold that the trial court was correct in coming to the finding it did. Coming to the question of limitation, the whole matter hinges on the point whether or not time was the essence of the alleged contract. From the plaintiff's own showing, it is clear that Dobby undertook to perform her part of the contract within 15 days from the date of the alleged agreement. Much reliance has been placed by the learned counsel for the appellant on the ruling in the case of Ramakrishna and another versus Lasmi Narayan and another 4, where it was observed that ordinarily in agreements for sale of property, time is not of the essence of contract, but this is not a general rule which is always applicable to all cases in which sale of property is involved. Each case must be determined on its own merit. In the same case, Alluded to above, it was also remarked that parties to a contract could expressly or impliedly bind their conduct, made time the essence of the contract. In K. Sayanara Yanamadi versus Sayanara Yanamadi 5, it was also held that, though ordinarily time is not the essence of contract to sell land, yet it can be made so by the parties. Therefore, it was the intention of the parties which must be considered as a factor in determining whether or not time was the essence of the contract. In the present case before me, it is in evidence that the plaintiff first wanted to have the transaction completed on the next day. It was only at the request of the defendant that an agreement was reached by which Dobby promised to implement her part of the contract within 15 days from the date of the original contract. Thus, it seemed clear to me that amongst themselves the parties have definitely chosen a time limit within which the terms of the contract were to be completed. There is nothing vague or indefinite about the time phase, since it was clearly laid down as 15 days. My attention has also been invited to AIR 1944 Madrid 218, where it was held that the stipulation regarding the execution of the deed to be done when the brothers returned to the village was held to be too indefinite to be regarded as fixing a day for the performance of the contract, but the present case before me is plainly distinguishable, inasmuch as the time fixed was not indefinite. A concrete 15 days was stipulated within which the contract was to be performed. Therefore, agreeing with the concurrent finding of the two courts below, I would hold that the course of action in this case arose as early as the 28th November 1959, when the defendant failed to perform her part of the contract, as the suit was filed only on the 15th January 1964. It was clearly time-barred. In the result, this appeal fails and is hereby dismissed with costs throughout. Advocate fee fixed at 3 gold mohurs.